The red and blue lights flash in my rearview mirror, and I feel that familiar tension creep up my neck. I pull over, kill the engine, and roll down the window. My hands are on the steering wheel, palms up, where he can see them. The officer approaches slowly, his eyes doing that quick scan of the interior that we all recognize. He asks for my license and registration, and I hand them over without any sudden movements. Then he pauses, looks from my license to me, and back into the truck. "Sir," he says, his voice dropping that initial layer of routine politeness, "do you have any firearms in the vehicle?" That question. It's the one that separates a routine stop from a potentially tense encounter. How you answer, how you move, even how you breathe in that moment can change everything. Here's a question for you, and I'm genuinely curious. What's been your experience when an officer has asked about a firearm during a stop? Have you ever been in a situation where you weren't sure if you had to disclose or where you felt like your rights were being tested? Drop your story in the comments below. I want to hear about the real-world encounters you've navigated. Don't go anywhere, because I'm about to reveal something in this video that might change how you view every single interaction with law enforcement. There's a specific dangerous trap that even the most well-meaning gun owners fall into, a critical mistake that effectively surrenders a right they never realized they had. I'm talking about the kind of mistake that can turn a routine stop into a legal nightmare, and I'll get to that in just a moment. The Supreme Court just dropped what can only be described as an enforcement order that has shattered the iron curtain of gun laws that anti-gun states have been constructing for years. This isn't just another ruling. This is a directive. It's the court telling states in no uncertain terms that their game of whack-a-mole with the Second Amendment is over. We've been watching this unfold since Bruen came down in 2022. That was the case that told New York and other states they couldn't make it practically impossible to get a concealed carry permit. It established that the Second Amendment protects a right to carry in public and that any gun law must be justified by the nation's historical tradition of firearm regulation. It was a massive win, a seismic shift that put the anti-gun states on notice that their games were over. But what did they do? They adapted. They took the fight to another front. Since they couldn't make it as hard as possible to get a permit, they decided to make it as hard as possible to use that permit. Their strategy was the sensitive places designation. Places that, according to history, have always been off-limits, like courthouses, legislative assemblies, and polling places. Sure, we can all understand that. But these states took the concept and ran with it. They stretched the definition to cover everything but the kitchen sink. We saw it in New York, where they tried to ban concealed carry in Times Square and on the subways. I remember reading some of the arguments for that, and it felt like they were grasping at straws to find historical analogies. They compared Times Square to a medieval fair or a market town to justify the ban. Seriously? It's a stretch if I've ever seen one. New Jersey tried to lock down parks, beaches, libraries, and a ridiculous number of other places. And then you had Hawaii with what they called the vampire rule. If a business didn't put up a sign explicitly saying, "Guns are welcome," it was a de facto gun-free zone. It was death by 1,000 cuts. Now, let's talk about why these tactics were so dangerous, not just for our rights, but for us as individuals. Think about trying to navigate your daily life in a state like New Jersey. You're running errands, heading to the grocery store, maybe stopping by a park. Each one of those locations might be a felony if you cross the threshold while carrying. And who knows? The signs are often unclear, or the laws are written so vaguely that you can't even figure out the boundary lines. This wasn't about protecting sensitive places. It was about creating a minefield for law-abiding citizens. The left's argument in New Jersey was that these were places where people gather, so they should be sensitive. But as the Supreme Court pointed out in Bruen, you can't effectively declare the entire island of Manhattan a sensitive place just because it's crowded. This was a deliberate attempt to make legal carry so complicated, confusing, and legally fraught that nobody would dare do it. When the Supreme Court finally took up the Hawaii case, Wolford versus Lopez, they were looking at a very specific part of the problem. Was the vampire rule constitutional? Could a state presume that you're a criminal unless a private business owner takes the time to tell you it's okay to be there? The answer came down on June 25, 2026, and it was a resounding 6-3 no. Justice Samuel Alito, writing for the majority, made the point perfectly clear. He said that Hawaii's law was often outcome determinative because if a business owner doesn't pay attention or doesn't care about the issue, the default is that you're committing a crime by walking in armed. The state tried to argue their law was justified by historical traditions. They pointed to old anti-poaching laws and some obscure laws from the Reconstruction era, but the court wasn't buying it. They saw the historical analogies as too wide a gap between things like keeping your firearm in a place where you shouldn't hunt and entering a grocery store or gas station. The court basically told the states that your right to self-defense doesn't evaporate the second you step onto someone else's property, even if that property is open to the public. This ruling is a direct hit against the game they were playing. You can't use silence as consent to restrict a constitutional right. It's not up to us to prove the store is open to us being armed. It's up to the store, if they so choose, to tell us we aren't welcome. This shifts the dynamic completely. It forces the choice onto the property owner, which is exactly where it should be. And this is the key to understanding the impact on all those gun-free zones in 30-plus states. Many of those state-level laws that prohibited firearms on private property open to the public are now on life support. They are functionally dead because the legal framework they relied on has been struck down. While the individual states might try to tweak their laws to match this new framework, maybe by offering free no-gun signs or passing affirmative choice laws, the era of the massive, sweeping presumption against carry is over. The court has drawn a line in the sand. You can't just create a massive default gun-free zone that covers 90% of the state and call it a day. Now, I want to connect this to that traffic stop scenario I opened with. The reason these default rules matter so much is that they create a legal minefield for average citizens. In a state like Hawaii, you could be driving down the street, completely legally carrying a firearm, and the officer has no idea that you're committing a crime until you cross the threshold of a gas station. That's a trap. That's the kind of law that turns ordinary people into criminals without them even knowing it. And this brings me to the dangerous mistake I mentioned earlier. It's the mistake of complacency. Many gun owners hear about these court rulings and think, "Great, the fight is over. The Supreme Court has spoken. I can just go about my business." But that's not how it works. The states are going to keep fighting. They're going to try new tactics. They're going to find new ways to restrict our rights. The Maryland Attorney General's statement is proof of that. He said, "We disagree with today's decision, and keeping Marylanders safe remains my office's top priority." They're not going to just roll over. The mistake is assuming that because the law is on your side, everything will be fine. The mistake is getting complacent. You have to be prepared for these interactions. You have to know the law. You have to practice your response. "Officer, I have a valid concealed carry permit. I am currently carrying a firearm. How would you like me to proceed?" It's professional. It's clear. It demonstrates you know the law and you respect the officer's safety. I've seen the consequences of getting this wrong. A friend of mine, a guy who'd been carrying for years, got pulled over in a duty-to-inform state. He was nervous, not because he was doing anything wrong, but because he'd never had the interaction before. When the officer asked for his license, he blurted out, "I have a permit and I'm carrying a gun." The officer stepped back, put his hand on his weapon, and ordered my friend to keep his hands visible. The stop went from a simple traffic violation to a high-tension felony stop. It could have been avoided with a calm, professional response. Another guy I know made the opposite mistake. He was in a state that didn't have a duty to inform, so he thought he didn't have to say anything. The officer asked if he had any weapons in the car, and he said, "No." The officer saw a gun case in the back seat and asked about it. My buddy said, "Oh, that's just my rifle. I was coming back from the range." The officer said, "You just told me you didn't have any weapons." My buddy said, "Well, I didn't think you meant that." That kind of response is going to get you into trouble. Honesty is always the best policy, even if you think you don't have to say anything. Here's the thing. An officer's primary concern is their own safety. They don't care about the politics of the Second Amendment. They care about going home to their family at the end of their shift. When they ask about weapons, they are checking for threats and assessing your behavior. They are watching your hands, your eyes, and your tone. They are looking for signs of deception. That's why a calm, direct answer de-escalates. A fumbled response escalates. I've seen it. A few years ago, a friend of mine who'd been carrying for years but never been pulled over got stopped for speeding. He was nervous. When the officer got to the window and asked for his license, my friend blurted out, "I have a concealed carry permit and I have a gun." The officer stepped back, put his hand on his weapon, and ordered my friend to keep his hands visible. The stop went from a simple speeding ticket to a high-stakes felony stop. The officer ended up being professional, but my friend was scared, and the officer was on edge. It could have been avoided if my friend had just kept his mouth shut until the officer specifically asked about weapons, or if he had said something less alarming like, "Officer, I'm a permit holder. I have a firearm. How would you like me to proceed?" It's all about the delivery. This kind of nervousness is what the anti-gun side loves. They count on it. They want the law to be so complicated and the penalties for violating them to be so severe that you're too scared to exercise your rights. But we can't let that happen. We need to be calm, we need to be prepared, and we need to know the law. Now, when I say these states are going to fight back, I'm not speculating. Look at New York. Their response to Bruin was the Concealed Carry Improvement Act, which basically tried to create a list of sensitive places longer than a CVS receipt. They've been hauled into court over it, and lower courts have upheld some of their bans, like on Times Square and the subway, using this crowded place historical analogy. But the Supreme Court has now said, no, you can't just ban carrying in crowded places. The legal foundation of those rulings is now built on sand. They're likely heading back to the Supreme Court, and the High Court might be very interested in taking a look at them. The fight is far from over. We're in a period of flux. The Bruin decision set the standard, text, and history. The Wolford decision clarified that you can't create a broad, unconstitutional default rule. And there are other cases like Coons versus New Jersey and the Maryland case about state parks and mass transit that are working their way through the system. The court hasn't weighed in on the specific list of places like parks or public transit in a definitive way. But the more these states push these absurdly broad restrictions, the more likely they are to end up in front of the justices. And when they do, I think the court is going to have to lay down an even clearer marker. A sensitive place isn't just anywhere the government says it is. It requires a specific historical tradition of being off limits, and crucially, it requires the government to provide comprehensive security. Justice Alito has hinted at this. The court has pointed out that for a place to be sensitive, the government has to actively protect it, like a courthouse with metal detectors and armed marshals. If they're not going to screen everyone entering a public park or a subway, they can't justify disarming the law-abiding citizens who are there. It's that simple. There was this fascinating article I read about how courts were actually misled by a fake citation from a privately published book to justify some of these place restrictions. It's incredible. Judges were citing a book as if it were North Carolina law, but it was just a private collection of English statutes that included the 1328 Statute of Northampton. The original law didn't say you couldn't be armed in a fair or market. It said you couldn't go armed in a manner to terrorize others. It's completely different. And our courts were using this error to uphold wide-ranging gun bans. This is the level of scrutiny we're dealing with. So, what does this all mean for you and me? First, the legal landscape is shifting in our favor. The days of massive default gun-free zones are numbered. The Supreme Court has started to dismantle the machinery that states like New York, New Jersey, California, and Hawaii built to circumvent Bruin. We won. Second, and this is the uncomfortable part, we have to be smart about it. In that traffic stop scenario, the nervous guy who gives the wrong answer or makes a sudden move is putting himself in a world of trouble. You're not just responsible for your rights, you're responsible for the officer's safety and your own. You don't want to end up on the ground with a knee in your back because you went for your wallet without announcing you had a gun. Practice your response. Officer, I have a valid concealed carry permit. I am currently carrying a firearm. How would you like me to proceed? It's professional. It's clear. It demonstrates you know the law and you respect the officer's safety. And third, don't fall for the trap of thinking, well, the court said this, so it's settled. It's not. The anti-gun states will never stop fighting. They'll appeal, they'll pass new laws, they'll try a new angle. They'll argue that a no-guns sign is the property owner's right, which it is, but they'll try to make it easier for businesses to put them up. They're already planning their next move. So, we need to stay vigilant. We need to support organizations that are fighting these legal battles. And most importantly, we need to be the best possible examples of responsible, law-abiding gun owners. Because every time you interact with law enforcement calmly and professionally while legally carrying, you're not just protecting yourself, you're building goodwill. You're showing that the people who oppose our rights are wrong. You're a walking, talking rebuttal to their arguments that we're a danger to society. We've taken a massive step forward with the Wolford decision, but the war for our rights will continue in state legislatures and courtrooms across this country. It's a fight we can't afford to lose. Stay informed, stay safe. And remember, the fight isn't over just because we won one battle. The need to be cautious, the need to be smart, and the need to protect our rights are here to stay. Stay safe out there.